Case 1. Ramsay Carpenter Burse. A former Miss Kentucky. A middle school science teacher. A woman who had stood on a national pageant stage and competed for a crown that represented scholarship, service, and character. And in 2018, that same woman was placed under arrest for sending explicit photographs to a 15-year-old student. This is Case 1. This is the case of Ramsay Carpenter Burse. Ramsay Bethan Carpenter was born on December 15, 1990, in Owensboro, Kentucky. From a young age, she pursued both academic achievement and competitive pageantry. Those two paths came together in a defining moment on July 12, 2014, when she was crowned Miss Kentucky 2014 in the Miss America system. That night she walked onto a stage in front of her state, wearing a crown that carried real weight. Her platform was multiple sclerosis awareness, a cause she understood deeply because at the age of 19 she had received that diagnosis herself. She went on to compete at Miss America 2015 in Atlantic City, New Jersey. She performed a bluegrass fiddle routine that earned her the Preliminary Talent Award and placed her in the national top 12. She was not just a title holder. She was a contestant who had demonstrated genuine ability on one of the most watched pageant stages in the country. After her year of service concluded, Carpenter pursued a career in education. She became a science teacher at Andrew Jackson Middle School in Cross Lanes, West Virginia, part of the Kanawha County school system. She also coached the school's cross-country team. She held federal licensure, a state teaching certificate, and the trust of students, parents, and administrators who had placed her in a position of direct responsibility over children. In the fall of 2018, investigators received a report that would change everything. The victim in this case was a 15-year-old male student, identified in court records only as Juvenile Victim 1, who was a former student of Carpenter's. Between approximately August and late October of 2018, Carpenter sent at least 4 explicit images of herself to this minor through the social media platform Snapchat. The student sent an image in return. The conduct was discovered by the victim's mother, who found the images on her son's phone and immediately contacted law enforcement. The Kanawha County Sheriff's Office opened an investigation. The lead investigator was Sergeant Brian Humphreys. The case was built almost entirely on digital forensic evidence. The images had been screenshotted and preserved on the minor's device before Snapchat's disappearing content feature could eliminate them. That digital record became the foundation of the prosecution. On December 7, 2018, Ramsay Carpenter was arrested by the Kanawha County Sheriff's Office. She was released on bond. She was immediately removed from her teaching position. The Kanawha County Board of Education placed her on administrative leave, and she later resigned. Prosecutors charged her with 4 felony counts of distribution or display of obscene matter to a minor under West Virginia Code, Sections 61-8A-2 and 61-8A-4. The maximum exposure on those counts was substantial. However, the case proceeded toward a negotiated resolution. On December 17, 2019, Carpenter appeared before Kanawha County Circuit Judge Lewis H. Bloom in Charleston, West Virginia. She pleaded guilty to a single reduced felony count of possession of material depicting minors in sexually explicit conduct under West Virginia Code, Section 61-8C-3. The 3 remaining original counts were dismissed as part of the agreement. Sentencing was not immediate. The process was delayed twice. First, so that the court could receive a formal psychiatric evaluation of the defendant, and second, due to the disruption caused by the COVID-19 pandemic. The sentencing hearing ultimately took place on July 15, 2020. It was conducted remotely via Skype, an unusual format that reflected the state of the courts during that period. The hearing was attended by the victim's mother, who delivered a statement directly to the court. She said, in part, that Carpenter had been placed in a position of trust over children, and that the defendant had used that position not to protect them, but to harm one of them. Her words were measured, clear, and direct. Carpenter herself addressed the court. She stated that because she was the adult and the student was a teenager, the responsibility for what happened was hers. She said, in her own words, that she had made a serious error in judgment. Defense attorney Tim DiPiero argued that incarceration posed a specific physical risk to Carpenter because of her multiple sclerosis diagnosis. He also argued on the basis of the psychiatric evaluation. The court considered both arguments. Assistant Kanawha County Prosecuting Attorney Michelle Jarrett presented the state's position. She argued that the relationship between a teacher and a student carries one of the most fundamental obligations of trust in any professional setting, and that Carpenter had violated that trust in a direct and documented way. Judge Lewis H. Bloom rejected the defense's request for a non-custodial sentence. He said that the position of trust Carpenter held was among the most important factors in his sentencing decision. He noted that the defendant had shown insufficient acceptance of responsibility. He then imposed the sentence. Ramsay Carpenter Burse received 2 years in state prison, 10 years of supervised release to follow, and lifetime registration on the sex offender registry. She surrendered to Lakin Correctional Center on July 20, 2020. No appeal has been publicly reported following the sentencing. A civil action against the Kanawha County Board of Education was announced by the victim's family at the time of sentencing. The filing status and outcome of that potential suit have not been confirmed in available public records. The defendant's teaching certificate was surrendered as part of the proceedings. Her career in education ended permanently. This case raised documented questions about the school system's response protocol. According to reporting by WCHS and WV Metro News, there were allegations that administrators had received some form of prior information before the formal report was made. The Board of Education has not confirmed those allegations publicly, and no disciplinary action against school administrators was reported in the court record. From a forensic standpoint, this case illustrates how social media platforms, even those designed around disappearing content, can still produce permanent evidence when a recipient screenshots the material before it vanishes. Digital forensics investigators have noted this as a recurring evidentiary pattern in cases involving minors and electronic communication. Ramsay Carpenter Burse held a Miss America preliminary title, competed on a national stage, served her state as a public ambassador for a legitimate health cause, and then was convicted of a crime against a child she was entrusted to educate. The title did not protect her from prosecution. The conviction, the sentence, and the lifetime registry requirement are matters of permanent public record in the state of West Virginia. Court records, conviction documents, and sentencing coverage are available through the Kanawha County Circuit Court, the Charleston Gazette-Mail, WV Metro News, and the original CNN and CBS News reports from July of 2020. If you are finding this series valuable, hit the like button right now. Your support helps this channel reach more people. Let us move to Case 2. Case 2, Trinity Madison Poague. An 18-month-old child died. The evidence pointed to the woman who had been left alone with him. That woman had competed in pageants, held a crown, and was a freshman in college when the investigation began. Within a year, she was standing trial for murder. This is Case 2. This is the case of Trinity Madison Poague. Trinity Madison Poague was a freshman at Georgia Southwestern State University in Americus, Georgia, enrolled in the Jimmy Carter Leadership Program. She had previously held the title of Miss Donalsonville 2023, a local Georgia pageant operated by the Miss Donalsonville Pageant Association under the direction of Danielle Long. She had also competed in the Miss National Peanut Festival pageant in Dothan, Alabama, in October of 2023. By January of 2024, Poague was in a relationship with a fellow university student named Julian Williams. Williams had a son from a prior relationship, an 18-month-old child named Romeo Angelus, also known by the nickname J.D. Romeo, had been born on June 25, 2022. His mother was Shaila Angelus. On January 14, 2024, Julian Williams left the Oaks II dormitory on the GSW campus in Americus for approximately 35 minutes to make a run to a nearby Walmart. During that window, Trinity Poague was alone with Romeo. When Williams returned, the child was unresponsive. Emergency services were called. Romeo Angelus was transported to Phoebe Sumter Medical Center. He was pronounced dead. He was 18 months old. The Georgia Bureau of Investigation was notified the same afternoon. Special Agent Samantha Fort took the lead on digital forensics. What she found on Poague's phone became central to the prosecution. Investigators recovered internet search queries Poague had entered while at the hospital following the child's transport. Among them, how do you get a brain bleed? And how can a depressed skull fracture go unnoticed? Those searches were conducted in the hours after Romeo was taken to the hospital. Investigators also recovered text messages from Poague's phone sent to her roommate. In those messages, Poague had written that she could not stand being around the child anymore and described a mutual hostility between herself and Romeo. The medical examination conducted by the Sumter County Deputy Coroner, Mathis Wright, found injuries that were inconsistent with accidental causes. The emergency room physician, Dr. Michael Bussman, also testified that the nature of the injuries was not consistent with an ordinary fall. Autopsy findings identified an impression on the child's face described as compatible with either a firm grip or a forceful contact. Poague was arrested on January 19, 2024, 5 days after Romeo's death. She was released on a $75,000 bond in February and was permitted to return to the university. The Miss Donalsonville Pageant Association stripped her of her crown in March of 2024. A 6-count indictment was returned by a Sumter County grand jury and announced on June 7, 2024. The charges were malice murder under Georgia Code Section 16-5-1, 2 counts of felony murder, 2 counts of aggravated battery under Section 16-5-24, and first-degree cruelty to children under Section 16-5-70. The trial opened in Sumter County Superior Court on December 2, 2025. The case was prosecuted by District Attorney Lewis R. Lamb. The defense was led by Attorney W.T. Gamble III. The presiding judge was the Honorable W. James Sizemore, Jr. Over 4 trial days, the jury heard from medical experts, the digital forensics investigator, and considered the physical and electronic evidence compiled by the GBI. Court TV live-streamed all 4 days of proceedings, and the case received national media coverage from CBS News, WELB, and the New York Post. District Attorney Lamb's closing argument addressed what he characterized as the core of the prosecution's theory. He argued that Poague had expressed a clear desire to have children with Julian Williams, but not this child, not Romeo. He presented the internet searches, the text messages, the medical evidence, and the 5 separate explanations Poague offered investigators in the days after Romeo's death as evidence of consciousness of guilt. Those 5 explanations included that the child had rolled off a bed, that he had fallen from a chair, that he had fallen from an air mattress, that he had fallen during unsupervised play, and a reference to the child choking on food. Each explanation was presented by the prosecution as contradicted by the physical evidence. Defense Attorney Gamble urged the jury to apply caution and avoid reaching conclusions that were not fully supported by the evidence. He argued that the case against his client was built on inference rather than certainty. The jury deliberated for approximately 3 hours. On December 5, 2025, they returned a verdict acquitting Poague on the charge of malice murder and convicting her on all 5 remaining counts: 2 counts of felony murder, 2 counts of aggravated battery, and first-degree cruelty to children. Judge Sizemore imposed the sentence within the hour. Poague received life in prison with the possibility of parole after serving 30 years on the felony murder conviction. She received a concurrent 20-year sentence on the cruelty to children charge. The remaining counts merged for sentencing purposes. Julian Williams, the child's father, was not charged. Investigators cleared him based on the timeline and the evidence recovered from Poague's device. As of April 18, 2026, no notice of appeal has been publicly reported. No civil suit from the child's family has been filed in available public records. The Romeo Angeles case illustrates how digital evidence, specifically, internet search histories conducted in real time following an incident, can serve as a critical investigative tool. Special Agent Samantha Fort's digital forensics work was described by the prosecution as the single most significant piece of evidence in the case. The case also demonstrates the investigative value of text message records, which provided documented context for the relationship between the defendant and the child prior to his death. Romeo Angeles was 18 months old when he died. His case was investigated by the Georgia Bureau of Investigation, prosecuted in Sumter County Superior Court, and fully adjudicated through a jury trial. The verdict and sentence are matters of permanent court record in the state of Georgia. Primary sources: GBI press release of January 19, 2024, court TV trial coverage, CBS News Atlanta, the Donalsonville News, and verified reporting from WELB News and WTVM. Stay with us. Case 3 is next. Case 3, Glennis Zapata. A federal drug trafficking indictment. A Mexican cartel. A private jet seized at a regional Indiana airport loaded with narcotics. And at the center of the money laundering operation, a woman who had once worn a crown as Miss Indiana Latina. Glennis Zapata, 34 years old at the time of her indictment, was a resident of Lafayette, Indiana. She had been crowned Miss Indiana Latina 2011, the Indiana state preliminary in the Miss U.S. Latina competition system, one of the oldest and most established Latina pageant organizations in the United States, founded in 1983. Reports indicate she was the first Indiana delegate in the competition's history to finish in the national top 10. Following her pageant career, Zapata became a commercial airline flight attendant. She held federal certification that included a known crew member designation, a Department of Homeland Security credential that allows credentialed airline crew members to bypass standard passenger screening at commercial airports. Investigators would later allege that this credential became one of the tools she used to carry out financial crimes on behalf of an international drug trafficking organization. The organization at the center of the federal case is identified in court documents as the Espinosa Drug Trafficking Organization, a Mexico-based cocaine trafficking network allegedly led by a man identified as Oswaldo Espinosa, known by aliases including Gordo, Ozzy, and Scrambler. As of April 2026, Espinosa remains a fugitive on the Drug Enforcement Administration's most wanted list. The DTO operated shipping and distribution networks across Mexico and into the United States, and it allegedly generated enormous sums of cash that required laundering before it could be used or transferred. According to investigators, Zapata's role was to transport drug proceeds, large amounts of cash, on commercial flights, using her known crew member status to avoid the screening that would have flagged the currency. Federal prosecutors identified 2 specific cash transports in the charged conduct. The first occurred on August 7, 2019, when Zapata allegedly transported $170,000 in drug proceeds. The second occurred on September 10, 2019, involving $140,000. Together, the 2 charged transports total $310,000. The broader investigation into the Espinosa DTO began well before the charges against Zapata were filed. In November of 2021, federal agents seized a 1987 Bombardier CL-600 jet, tail number XAUFF, at Gary Chicago International Airport in Gary, Indiana. That aircraft was found to contain approximately 100 kilograms of cocaine. Further seizures connected to the same DTO included an additional 175 pounds of cocaine from a Lincoln Navigator and 44 pounds from passenger luggage. Investigators calculated the total cocaine volume connected to the DTO's operations in the charged period at more than 1,200 pounds. The investigation was conducted jointly by the Drug Enforcement Administration, Homeland Security Investigations, IRS Criminal Investigation, and U.S. Customs and Border Protection. On May 16, 2024, a superseding federal indictment was filed in the United States District Court for the Northern District of Illinois, Eastern Division. The case is docketed as United States v. Espinosa et al., case number 1:23CR00426. The indictment was unsealed on May 17, 2024, and announced publicly by acting United States Attorney Morris Pasquale. Glennis Zapata is named in 2 counts of money laundering under 18 United States Code Section 1956, and in the broader money laundering conspiracy charge that ties the defendant network together. Presiding over the case is United States District Judge Jorge L. Alonso. Defense counsel for Zapata is attorney Michael John Petro. Following arraignment, Zapata was released on a $20,000 bond. The indictment names 18 co-defendants in total. Among the most significant is Zapata's sister, Ilene Zapata, a bank teller who is accused of taking large volumes of small denomination bills connected to drug proceeds and exchanging them for larger denominations, a common money laundering technique, involving approximately $400,000. 2 additional bank employees, including a teller named Georgina Banuelos, are also named in the indictment. Ricardo Tello, identified as the Chicago area manager for the DTO, is also charged. This case represents one of the largest federal drug trafficking prosecutions to have originated from Indiana in recent years. It illustrates the federal government's documented use of multi-agency task force investigations to dismantle entire organizational networks rather than pursuing individual actors in isolation. The known crew member designation, the federal credential Zapata allegedly exploited, has since received increased scrutiny from aviation security analysts who note that the program was designed to reduce friction for legitimate crew members, not to create an unmonitored channel for illicit activity. The TSA has not publicly commented on policy changes in connection with this specific case. As of April 18, 2026, no plea, verdict, or sentence has been entered in Zapata's case. The prosecution remains pending in the Northern District of Illinois. The case is ongoing. Primary sources for this case: the Department of Justice press release issued May 21, 2024, by the United States Attorney's Office for the Northern District of Illinois, the Drug Enforcement Administration press release of the same date, the unsealed superseding indictment entered at docket entry 195, reporting by ABC7 Chicago, the Chicago Sun-Times, News Nation, Fox News, and Law and Crime. The Miss Indiana Latina organization issued a public statement at the time of the indictment describing the charges as an isolated incident unrelated to the organization. Zapata has not made public statements outside of court proceedings. This case will be one to watch. A resolution is expected as the federal docket continues to move. We will follow it on this channel as it develops. Up next, Case 4. Case 4. Brandy Lee Weaver Gates. She told her community she had cancer. She showed up to charity events in a wheelchair. She shaved her head. She attended hospital appointments. Her family drove her to cancer centers across 3 states. And every single word of it was a documented lie. This is Case 4. This is the case of Brandy Lee Weaver Gates. Brandy Lee Weaver Gates was 23 years old and a resident of Pleasant Gap, Pennsylvania, in Centre County when her deception was first reported to law enforcement in the summer of 2015. She held the title of Miss Pennsylvania United States International 2015, the state preliminary competition operated by Butler's Beauties, a legitimate and organized pageant system distinct from the Miss America and Miss USA organizations. The scheme Weaver Gates constructed began in March of 2013, more than 2 years before anyone reported it to police. She told family members, friends, and her broader community that she had been diagnosed with chronic lymphocytic leukemia. She presented the diagnosis not as a private medical matter but as a public cause, building around it a community fundraising effort that would eventually involve hundreds of people. She created the physical appearance of illness. She shaved her head. She appeared at events in a wheelchair. She wore 4 bandages and surgical masks consistent with a patient undergoing treatment. She made repeated trips to major medical institutions across multiple states, including Johns Hopkins Medical Center, Geisinger Medical Center, and UPMC Hillman Cancer Center's Weinberg facility, with family members accompanying her and waiting in lobbies while she went inside. In fact, she never received treatment at any of these facilities. She walked the hallways and left. The fundraising that grew around her fabricated diagnosis was substantial. The signature event was a gathering called Bingo for Brandy, held on April 10, 2015, in Howard, Pennsylvania. That single event raised more than $14,000. A separate event held in September of 2013, Brandy's Benefit Bash, contributed additional funds. In total, investigators identified at least 165 individual victims and calculated that the scheme generated approximately $30,000 in fraudulent charitable contributions. The investigation was triggered by an anonymous letter sent to Pennsylvania State Police Troop G at the Rockview Barracks in late June or early July of 2015. The letter raised questions about the legitimacy of Weaver Gates's claimed diagnosis. The letter was assigned to Trooper Thomas Stock, who described the case as unlike anything he had encountered in his career. Trooper Stock's investigation proceeded methodically. He issued subpoenas for medical records from all 4 of the institutions Weaver Gates claimed to have attended as a patient. Johns Hopkins returned no records. Geisinger returned no records. UPMC Hillman returned no records. Weinberg returned no records. Weaver Gates could not, when questioned, provide the name of a single treating physician. Investigators then subpoenaed the financial accounts connected to the fundraising efforts, including the dedicated donation account that had been set up in her name. A review of social media records was also conducted, documenting the timeline and nature of her public representations about her health status. Weaver Gates was arrested and arraigned on August 11, 2015. Her bond was set at $150,000. She could not post it and was held in pretrial custody. Butler's Beauties, the organization holding her Miss Pennsylvania United States International title, stripped her of the crown on the day of her arrest. The original charges filed were felony theft by deception under 18 Pennsylvania Consolidated Statutes, Section 3922, and felony receiving stolen property under Section 3925. In early 2016, prosecutors added 3 additional counts of each charge as the investigation identified more victims and more specific transactions. Weaver Gates pleaded guilty in June of 2016. In a statement to the court, she said she had fabricated the illness to obtain more attention from her family. Sentencing was held on July 26, 2016, before Judge Thomas K. Kistler of the Centre County Court of Common Pleas. The prosecutor was Centre County District Attorney Stacey Parks Miller, who stated at sentencing that the defendant had stolen not just money but time and attention from people who were genuinely suffering from cancer. Defense representation was provided by Public Defender Deborah Lux. Judge Kistler imposed a sentence of 2 to 4 years in state prison, 5 years of probation to follow, and full restitution in the amount of $30,000. Credit was applied for time served in pretrial custody. No co-defendants were charged in connection with this scheme. No successful appeal has been reported in public records. Restitution was handled through the criminal judgment rather than separate civil litigation. The Weaver Gates case is frequently cited in academic and legal discussions of charity fraud because of its extended duration, the sophistication of the deception, and the specific targeting of community goodwill around a serious medical diagnosis. The investigation demonstrates how subpoena-based medical record verification can definitively dismantle a false illness narrative. The absence of records from 4 major institutions, combined with the defendant's inability to name a treating physician, eliminated any viable defense. 165 victims gave money to a cause that did not exist. $30,000 was collected over more than 2 years. The prison sentence, the probation, the restitution order, and the stripped crown are all matters of permanent public record in Centre County, Pennsylvania. Case 5 is next, and it may be the most documented case on this entire list. Case 5, Clara Harris. A private investigator's camera was rolling the entire time. The footage captured a silver Mercedes striking a man in a hotel parking lot, more than once. The woman behind the wheel had been crowned in a local beauty pageant. Her husband was having an affair. And on the night of July 24, 2002, David Harris died from his injuries in Nassau Bay, Texas. This is Case 5. This is the case of Clara Harris. Clara Lydia Suarez Harris was born on February 3, 1958 in Bogota, Colombia. She emigrated to the United States, completed a dental residency at the University of Texas Health Science Center at Houston's dental branch, and established herself as a professional dentist in the Houston metropolitan area. She later became co-owner of a dental practice with her husband, David Lynn Harris, an orthodontist operating Space Center Orthodontics. Clara was also crowned Miss Columbia Houston, a title in a local Colombian American community pageant. The title was not part of the Miss America or Miss USA systems, but it was an organized community competition recognized and covered by local Houston media. Texas Monthly's Skip Hollandsworth documented it in his long-form investigative feature on the case. David and Clara Harris married on February 14, 1992, Valentine's Day. By 2002, they had twin sons together, named Brian and Bradley, who were 4 years old. David also had a teenage daughter from his first marriage, Lindsay Diane Harris, who was 16 at the time of the events. In the period leading up to July 2002, Clara Harris became aware that her husband was in a relationship with Gail Thompson Bridges, a former receptionist at their dental practice. Clara responded by hiring a private investigation firm, Blue Moon Investigations, operated by Bobby Bacha, to monitor her husband's activities. It was that decision that would place a camera at the scene on the night David Harris died. On the evening of July 24, 2002, Clara went to the Nassau Bay Hilton in Nassau Bay, Harris County, Texas, having learned that David and Bridges were meeting there. She brought Lindsay Harris with her. After a confrontation inside the hotel lobby involving Bridges, Clara returned to the parking lot, entered her silver Mercedes-Benz S-Class 430, and used the vehicle to strike David Harris. According to the trial record and the testimony of Lindsay Harris, the vehicle struck David Harris more than once. David was declared dead at 9:48 that evening. The cause of death was the injuries he sustained in the parking lot. A Blue Moon surveillance operative was present throughout and captured portions of the event on video. That recording became one of the most significant pieces of evidence in the subsequent prosecution. Clara Harris was charged with murder under Texas Penal Code Section 19.02. The Harris County Grand Jury returned an indictment, and the case was set for trial in the 177th District Court of Harris County before the Honorable Judge Carol G. Davies. The trial opened on January 14, 2003. Lead prosecutor for the state was Harris County Assistant District Attorney Mia Magnus. The defense was led by attorney George Parnham, who was joined by attorney Emily Munoz de Toto. The trial drew extensive national media coverage and was attended by reporters from major news organizations across the country. The prosecution's case rested on several pillars. The surveillance video was presented to the jury. The testimony of Lindsay Harris was central. On the stand, Lindsay testified that before the car struck her father, Clara said she was going to hit him. She also testified that earlier in the evening, Clara had made a statement about being capable of causing serious harm and getting away with it. Lindsay was 16 years old when she gave that testimony, the daughter of the victim, testifying against her stepmother. The defense argued that Clara Harris had acted in a state of extreme emotional disturbance upon discovering the affair in real time, and that the vehicle contact was the result of a mental state that diminished her premeditation. George Parnham presented testimony centered on the psychology of betrayal and emotional response. The jury deliberated and returned a verdict of guilty on February 13, 2003. In the penalty phase, the jury made two additional findings. First, that the killing occurred as a result of sudden passion, as defined under Texas Penal Code Section 19.02 subsection D, which reduced the offense to a second-degree felony punishment range, and second, that the Mercedes-Benz had been used as a deadly weapon. Clara Harris was sentenced on February 14, 2003, the couple's 11th wedding anniversary. Judge Davies imposed 20 years in the Texas Department of Criminal Justice and a $10,000 fine. The 20-year sentence was the statutory maximum under the reduced punishment range. The conviction was appealed. The First Court of Appeals of Texas, located in Houston, issued its opinion on December 16, 2004, in the case captioned Harris v. State. The court affirmed the conviction in full. The Texas Court of Criminal Appeals declined further review. In the civil courts, the parents of David Harris, Gerald and Mildred Harris, filed a wrongful death action. That case proceeded to trial in the 281st District Court of Harris County. Clara Harris invoked her Fifth Amendment right against self-incrimination 27 times during civil discovery and courtroom testimony. The civil jury returned a judgment of $3.75 million in favor of the Harris family. Clara Harris served her sentence primarily at the Mountain View Unit in Gatesville, Texas. Parole was denied in April 2013 and again in September 2016. Parole was granted in November 2017. She was physically released from custody on May 11, 2018. Her parole supervision concluded on February 10, 2023. The Texas State Board of Dental Examiners revoked her dental license. The case was adapted into a CBS television film titled Suburban Madness, which premiered on October 3, 2004. The case also received coverage on national programs and was the subject of Stephen Long's book Out of Control, published by St. Martin's Press in 2004. The evidentiary record in this case is among the most complete in any homicide prosecution reviewed in this series. Surveillance video, stepdaughter testimony, the sudden passion jury finding, an upheld appellate opinion, a successful civil verdict, and full documentation of the parole and post-conviction record. Every element of the case can be traced to primary court documents. David Harris was 44 years old when he died. He left behind 2 4-year-old sons and a 16-year-old daughter who testified against her stepmother in open court. Case 6. Kumari Fulbright. She held 2 Miss America System titles in Arizona. She was a second-year law student with a federal judicial externship. And on December 8, 2007, she was at the center of an 8 to 10-hour kidnapping of her former boyfriend that resulted in federal felony convictions for everyone involved. This is Case 6. This is the case of Kumari Fulbright. Kumari S. Fulbright grew up in Arizona and pursued an academic and public service career that was, by any measure, remarkable. She held 2 Miss America System local preliminary titles, Miss Pima County 2005 and Miss Desert Sun 2006. She competed for Miss Arizona through those titles, but did not win the state crown. Her academic record was equally accomplished. By 2007, she was 25 years old and enrolled in her second year at the University of Arizona James E. Rogers College of Law in Tucson. She was simultaneously serving as an unpaid extern in the chambers of a federal judge in the United States District Court for the District of Arizona, a position that places law students in direct contact with the federal judicial system under supervision. The victim in this case was Joshua T. Conway, 24 years old, Fulbright's former boyfriend. Conway was not a law student. He was working in the Tucson area when the events of December 8, 2007 occurred. Fulbright contacted Conway and asked him to come to her Midtown Tucson duplex. What Conway encountered when he arrived was not a conversation. He was met by 4 men who had been organized, according to the prosecution, by Fulbright and her ex-fiancé, Robert Arthur Ergones. The 4 individuals, Ergones, his brother Michael Ergones, David Wainwright, and Larry Bruce Hammond, restrained Conway physically, displayed firearms, and accused him of theft. Specifically, they accused him of stealing jewelry that Fulbright had told Ergones was missing. Phone records introduced at the subsequent trial of Robert Ergones showed that the jewelry had not been stolen. Fulbright had authorized its sale. The accusation was fabricated. During the 8 to 10-hour period in which Conway was held, he was moved between 2 locations in the Tucson area. Fulbright was present. According to court records, she participated in the assault, biting Conway in multiple places, making physical contact with his neck and hands, and at one point retrieving a kitchen knife and threatening him with it. Conway was held, interrogated, and subjected to repeated physical contact throughout the night. He eventually freed himself. Evidence in the record shows that he was able to get hold of a weapon during a physical altercation that involved a discharge, and then fled barefoot to a neighboring residence, where he was able to contact help. The Pima County grand jury indicted all 4 men and Fulbright on December 18, 2007, on charges including kidnapping under Arizona Revised Statute Section 13-1304, armed robbery under Section 13-1904, aggravated robbery under Section 13-1903, and 2 counts of aggravated assault with a deadly weapon under Section 13-1204. The maximum combined exposure under those charges was well over 40 years. Kumari Fulbright rejected an early plea offer and faced the charges for approximately 2 years before reaching a resolution. On December 9, 2010, she appeared before Pima County Superior Court Judge Michael Miller. She pleaded guilty to conspiracy to commit kidnapping and aggravated assault. She was sentenced to 2 years in the Arizona Department of Corrections, 6 years of probation upon release, and $15,000 in restitution to Joshua Conway. Prosecutors in the case were Pima County Deputy County Attorneys Michael Jetta and Kim Ortiz. Defense representation across the life of the case was provided by attorneys Thomas Hartzell, Steve Weiss, and Steve Sherrick. Robert Arthur Ergones, the primary organizer, fled the jurisdiction, reportedly to Colombia, and was ultimately returned to the United States to face trial. He was convicted in November of 2010 on aggravated assault with a deadly weapon, kidnapping, and armed and aggravated robbery. Judge Miller sentenced him to 22.5 years in the Arizona Department of Corrections. David Wainwright pleaded guilty to conspiracy to commit kidnapping and received 4 years and 3 months, plus additional time for unrelated drug and weapons offenses. Larry Bruce Hammond pleaded to aggravated assault and received probation. The disposition of Michael Ergonis's case is not confirmed in available public records. Evidence in the prosecution of Fulbright and her co-defendants included physical photographs of marks on Conway's body, physical items recovered from the locations where he was held, testimony from the neighbor who received him when he escaped, and letters Fulbright had sent to Robert Ergonis through a family intermediary that were introduced against her co-defendant at his trial. The case did not end with the criminal sentences. In 2015, Fulbright appeared on MTV's One Bad Choice series, a documentary program focused on individuals who had made significant legal errors and used the platform to make public statements about Conway. Conway subsequently filed a defamation lawsuit in both state and federal court. In May of 2018, Fulbright executed a sworn legal admission stating that her public accusations against Conway were not supported by any proof, and she agreed never to use his name in a public setting again. Court costs in that proceeding were assessed against her. Kumari Fulbright had been admitted to law school, received a federal externship, and held 2 Miss America System preliminary titles when she organized and participated in the kidnapping of a former boyfriend. The legal consequences included criminal conviction, prison time, a 6-year probationary period, a civil defamation settlement, and a sworn retraction of public statements. Case 7 is one of the most unusual fraud prosecutions in the history of Alaska. Case 7, Rachel Leaud. She was a Rhodes Scholar. She had attended Oxford and KO University on fellowships. She had interned at the White House. And between 2003 and 2006, she obtained nearly $680,000 in federal student loans using 2 different identities to commit fraud. She was caught. She pleaded guilty to 15 federal felony counts. She was sentenced to 57 months in federal prison. This is Case 7. This is the case of Rachel Leaud. Rachel Leaud was born Rachel Hall. She grew up in Anchorage, Alaska. She was crowned Miss Anchorage 1996 in the Miss America System, a title confirmed on the official alumni list of the Miss Anchorage Scholarship Program. She went on to complete her undergraduate education at the University of California, Davis, and then at Stanford University, where she achieved a 4.0 grade average. She was awarded a Rhodes Scholarship for study at Oxford University and a Fulbright Scholarship for academic work at Keio University in Japan. She received the Congressional Gold Award and had served as a White House intern and as an unpaid research associate at the International Institute for Strategic Studies. By 2003, when the fraud scheme began, Leaud had established 2 legal identities. She had obtained a new Social Security number through the Social Security Administration's HAIL program, a victim protection mechanism, after securing a restraining order against her father, Robert Hall, in 2002. That new identity was in the name Rachel Leaud. Her original identity, in the name Rachel Hall, remained active in federal government systems. What followed was a methodical, long-running fraud scheme that exploited both identities simultaneously. Between August of 2003 and May of 2006, Leaud applied for and received 19 federal student loans totaling nearly $680,000. She used her old identity, Rachel Hall, as a co-signer on loans taken out in her new identity as Rachel Leaud. She submitted fabricated income documentation that claimed an annual salary of $525,000 from her unpaid internship at the International Institute for Strategic Studies. She forged letters on academic institution letterhead from Oxford University and Keio University to support her loan applications. The financial institutions she defrauded included the Alaska Commission on Post-Secondary Education, Sallie Mae, and USAA Federal Savings Bank in San Antonio. The academic institutions whose names she used without authorization included Oxford University and Keio University, in addition to several of her prior employers and vendors connected to her student publication, the Oxford International Review. Of the approximately $679,000 drawn down through the scheme, investigators calculated that approximately $403,000 was directed to non-educational uses. Among the most significant documented transfers was a wire of $237,975, sent on March 7, 2005, to a Smith Barney brokerage account in Hong Kong. That money was used for stock trading. Additional funds were directed toward the purchase of a condominium on 3rd Avenue in Anchorage. The investigation was conducted by the United States Postal Inspection Service and the Department of Education Office of Inspector General. The federal investigation identified the full scope of the scheme, the false documentation, the dual identity structure, and the uses to which the fraudulently obtained funds were directed. Poague was indicted by a federal grand jury in Anchorage on March 5, 2009. A superseding indictment later brought the total charge count to 15 federal felony counts, 10 counts of mail fraud under 18 United States Code Section 1341, 1 count of wire fraud under Section 1343, and 4 counts of making false statements to a financial institution under Section 1014. The statutory maximum exposure across all 15 counts was in excess of 200 years. Poague pleaded guilty to all 15 counts in June of 2010 before United States District Judge John W. Sedgwick in Anchorage. A 2.5-day sentencing hearing concluded on September 10, 2010. Prosecution was led by United States Attorney Karen L. Loeffler and Assistant United States Attorney Retta Ray Randall. Defense was provided by Federal Public Defender Richard Kurtner. At sentencing, Randall characterized the case as one not of abuse, but of lies and greed. Judge Sedgwick acknowledged that Poague's background was unusually accomplished while also noting the deliberate and sustained nature of the deception. On September 13, 2010, the Department of Justice issued a press release titled Rhodes Scholar and former Oxford student goes to jail. Judge Sedgwick had sentenced Rachel Lee Poague to 57 months in federal prison, 5 years of supervised release to follow, and approximately $750,000 in restitution to the defrauded financial institutions and agencies. Her husband, Brett Poague, who was never charged in connection with the scheme, filed for divorce following the conviction. No co-defendants were charged. No appellate reversal has been reported. This case is notable for its structural complexity. The dual identity framework Poague used, exploiting a legitimate victim protection program to construct a second legal identity and then weaponizing both simultaneously in a loan application scheme, required significant planning across a 3-year period. Federal investigators and prosecutors working this case had to reconstruct the entire dual identity architecture before charges could be filed, which contributed to the 6-year gap between the start of the scheme and the indictment. Rachel Poague held the title of Miss Anchorage in the Miss America system. She attended some of the most prestigious academic institutions in the world on merit-based awards, and she used those credentials, the fellowships, the academic reputation, the institutional letterheads, as tools to build a fraudulent loan application empire that netted nearly $700,000 over 3 years. Case 8 involves a Ponzi scheme, a Filipino-American community, a Las Vegas gambling habit, and a beauty queen title in Nevada. Case 8. Maria Dulce Pino Dickerson. She told investors she was placing their money into litigation funding loans with guaranteed monthly returns. She was not. She was spending it. The casino records, the mortgage documents, the luxury car purchases, and the bank transfers told a different story. And in March of 2026, she pleaded guilty to federal wire fraud and securities fraud. This is Case 8. This is the case of Maria Dulce Pino Dickerson. Maria Dickerson operated under multiple names throughout the period under review. Maria Dulce Pino Dickerson, Dulce Pino, and Dulce Brubaker. She was crowned Ms. Woman Nevada 2020, a state title in the United States National Pageant System's Married Women's Division for participants over 40. She held or claimed additional pageant credentials, but the Ms. Woman Nevada 2020 title is the one confirmed by independent reporting and regulatory filings. By the time investigators began to assemble the full picture of her financial activities, they had also documented 3 prior personal bankruptcies, filed in 2008, 2014, and 2019. Those bankruptcies had been concealed from investors. The scheme operated under 2 company names. The first was Creative Legal Fundings of California, LLC, abbreviated CLF. The second, opened after CLF began defaulting on investor obligations in May of 2023, was the Ubiquity Group, LLC. Both entities were described to investors as platforms for litigation funding loans, a structure in which investors provide capital that is lent to personal injury attorneys, who pay it back with interest after their cases settle. Dickerson pitched primarily to members of the Filipino-American community across California, Washington, Alabama, and other states. Federal prosecutors and the Securities and Exchange Commission characterized the targeting of a close-knit ethnic community as affinity fraud, a category of investment fraud that exploits shared identity, cultural trust, and community networks. Promised returns ranged from 10 to 17.5% per month. No such loans were being made. The funds were being used for Dickerson's personal expenses. The documented personal spending identified in the court record and SEC filings includes more than $280,000 at casinos in Las Vegas and California, $1 million in cash for a Sacramento residential property, $93,000 for a 2021 Mercedes-Benz GLE 350, $150,000 for a 2022 Mercedes-Benz EQS, more than $75,000 in travel expenses, more than $23,000 in designer merchandise, and additional funds directed toward pageant entry fees and private jet travel, expenses that supported her public image on social media and enabled her to attract additional investors. Total funds raised from victims is documented at more than $10 million in the Department of Justice's characterization of the scheme. The SEC complaint references approximately $7 million from more than 130 investors. The difference reflects different counting methodologies across the parallel regulatory and criminal proceedings. Named victims whose losses appear in filings include Geraldine Bartleson, a military spouse who lost approximately $80,000, Sarah Barcelona of Washington, who lost approximately $100,000, Ryan and Gemma Smith, who lost $200,000 and subsequently lost their Florida home, relocating to a recreational vehicle, and Ellie Dowling, among others. The investigation was conducted by the Federal Bureau of Investigation and IRS Criminal Investigation. The SEC filed a parallel civil action, Securities and Exchange Commission versus Dickerson et al., case number 2:24 at 01121, in the Eastern District of California. On September 3, 2024, a 32-count federal indictment was unsealed and announced by United States Attorney Philip A. Talbert. The charges comprised 24 counts of wire fraud under 18 United States Code Section 1343, 1 count of securities fraud, and 7 counts of money laundering. On March 10, 2026, Maria Dickerson appeared before Senior United States District Judge John Mendez in Sacramento. She pleaded guilty to 1 count of wire fraud and 1 count of securities fraud. The plea was announced by United States Attorney Eric Grant. The remaining 30 counts were addressed through the plea agreement. Sentencing is scheduled for July 28, 2026. Parallel enforcement actions against Dickerson were filed by the California Department of Financial Protection and Innovation, which issued a desist and refrain order in November of 2023. The Alabama Securities Commission and the Washington State Department of Financial Institutions, which imposed a $50,000 fine via a final order. 2 civil class actions are also pending. One in Sacramento, filed by more than 30 plaintiffs represented by attorney Audie DeCastro and seeking more than $2.6 million in damages, and a second in Washington filed by more than 40 plaintiffs. The Dickerson case is one of the most recent on this list and one of the most fully documented by federal regulatory agencies. The SEC, DOJ, FBI, IRSCI, and 3 state securities regulators all produced independent case records. The combination of a federal guilty plea, 3 prior bankruptcies, documented concealment of financial history, and affinity fraud targeting of a specific ethnic community made this one of the most thoroughly prosecuted financial fraud cases connected to any pageant titleholder in recent years. Sentencing in July of 2026 will determine the final penalty. This channel will provide an update when that sentence is imposed. Case 9. A crown, a gas station, a pharmacy, and a criminal charge. Case 9. Daniela Gaski. She was the first Miss Kentucky Latina. On September 29, 2010, she was arrested in Madison County, Kentucky, after a series of documented incidents at 2 separate businesses. She pleaded guilty. She received home incarceration and probation. And then the case continued to generate legal consequences for years afterward. This is Case 9. This is the case of Daniela Gaski. Daniela Gaski, who later went by Daniela Miles after a subsequent marriage, was crowned Miss Kentucky Latina 2010. The title was the Kentucky State Preliminary in the Miss U.S. Latina system, the same national Latina pageant organization within which Glennis Zapata, case 3 on this list, held the Indiana state title. According to available records, Gaski was the first woman to hold the Miss Kentucky Latina title in the competition's history. On September 29, 2010, Gaski was in the Richmond, Kentucky, area. Investigators and court records document that she was carrying a firearm and had been drinking. She approached the Swifty gas station on that date. When entry was refused, she used an ink pen to make contact with a male attendant's neck, causing an injury. She then crossed to the M&M drug store on the opposite side of the street. At M&M drug store, Gaski located the vehicle belonging to pharmacist Mary and McKinney, a silver Toyota Avalon, and began kicking it. McKinney came outside. A physical altercation followed in which McKinney sustained documented injuries including a kick to the abdomen, damage to her eyeglasses, lacerations to her neck, a cut to her lip, and a contusion to her head. Officers from the Madison County Law Enforcement responded to the scene. Gaski was taken into custody. Witnesses at the scene later identified Gaski's Miss Kentucky Latina sash, which was visible inside her vehicle, and reported the identification to journalists who covered the case. Marian McKinney was not aware of who Gaski was when the attack occurred. She learned the defendant's identity after friends who followed local news connected the name and the sash. Original charges filed by Madison County prosecutors included 2 felony counts, felony assault and felony criminal mischief, as well as disorderly conduct. The combined exposure on the original felony charges was up to 10 years. The case was resolved on November 10, 2010. Gaski appeared in Madison District Court before Judge Brandy O. Brown and pleaded guilty to 5 misdemeanor counts, including 4th-degree assault under Kentucky Revised Statute Section 508.030 and 2nd-degree criminal mischief under Section 512.030. Judge Brown sentenced Gaski to 360 days, with 180 days to be served on home incarceration under electronic monitoring. Additional conditions included mandatory psychiatric treatment, a prohibition on alcohol consumption, a prohibition on firearm possession for a period of 2 years, the surrender of her pistol permit, and a restriction barring her from working at Sling Point Firearms, a business owned by her then-husband, Scott Bond. Prosecutor was Madison County Attorney Mark Robbins. The case did not conclude with the plea. Within 24 hours of the sentencing, Sling Point Firearms was burglarized. A vehicle was driven through the front of the business, and multiple firearms, for handguns and 2 rifles, were stolen. Lexington television news footage captured an individual who appeared consistent with Gaski's description inside the building. Prosecutor Robbins filed a motion to revoke the plea agreement. The ultimate outcome of that revocation proceeding is not confirmed in the available public record. A separate matter arose involving photographs posted on a Facebook page associated with Sling Point Firearms, captioned Gun Bunnies, that allegedly showed Gaski at a Lexington fire station in uniform-adjacent attire. The Lexington Fire Department opened an internal investigation. Battalion Chief Marshal Griggs confirmed the investigation to local media. The outcome has not been confirmed in the public record. Scott Bond, Gaski's then-husband, was subsequently elected a constable in Mobile County, Alabama. He was convicted on federal firearms charges in Mobile in 2013. Gaski divorced Bond and later married Robert Miles, a Pritchard, Alabama police officer. She completed training at the Mobile Police Academy, passed the psychological evaluation and polygraph examination required for law enforcement certification, and was ultimately not hired by the Mobile Police Department. Gaski later gave on-camera interviews to WKRG in Alabama in which she characterized her conduct in the 2010 incident as the result of circumstances related to domestic violence she had experienced in that period of her life. Those statements have not been adjudicated in any subsequent proceeding identified in public records. The Miss Kentucky Latina organization formally stripped Gaski of her title on October 5, 2010, 6 days after her arrest. The Gaski case is notable for a number of procedural reasons. The plea reduction from felony to misdemeanor charges is an example of a prosecutorial resolution that weighs the strength of specific evidence, the profile of the defendant, and the capacity of a jurisdiction to pursue full felony prosecution. The post-conviction developments, the firearms burglary, the fire station photographs, the attempted plea revocation, illustrate how a criminal proceeding can generate secondary legal questions that outlast the original sentence. One case remains, and it is the one that is still being watched in courtrooms right now. Case 10, Lindsay Shiver. She was Miss Houston County, Alabama, 2005. She was living in the Bahamas, going through a divorce from a former Auburn football player. And in July of 2023, she was arrested and charged with conspiracy to commit murder for allegedly directing two men to kill her estranged husband. This is Case 10. This is the case of Lindsay Shiver. A critical note before we begin. Lindsay Shiver is a United States pageant title holder. However, the alleged crime occurred in the Bahamas, and she is being prosecuted in the Bahamian court system, not in a United States federal or state court. This distinction is important. All information in this case segment reflects Bahamian court proceedings and journalism from verified outlets. As of April 18, 2026, no verdict has been entered. The trial has been rescheduled multiple times. All charges at this time remain allegations. Shiver has pleaded not guilty. Lindsay Shirley Shiver, now 39 years old, was born and raised in Dothan and Houston County, Alabama. She was crowned Miss Houston County 2005, a title held through Houston County Pageants Incorporated in Dothan, Alabama, and competed as second runner-up at the Miss National Peanut Festival 2005 in Dothan. She is an alumna of Auburn University. She married Robert Shiver, a former long snapper for the Auburn University Tigers football program and subsequently senior vice president of Senior Life Insurance Company, based in Thomasville, Georgia. The couple had 3 sons together, Grayson, Landon, and Rhett Shiver. They owned a property at Baker's Bay Golf and Ocean Club on Guana Cay in the Abaco Islands of the Bahamas. On April 5, 2023, Robert Shiver filed for divorce in Georgia. Lindsay filed a counterpetition the following day, April 6. Their separation was in the early stages when, according to prosecutors, the events that led to the criminal charges began. Prosecutors allege that on July 16, 2023, Lindsay Shiver sent a WhatsApp group message containing photographs of Robert Shiver and the text instruction to kill him. The alleged recipients were Terrence Adrian Bethel, a bartender employed at Grabber's Bar and Grill on Guana Cay, and Bethel's associate, Farron Newbold Jr. The alleged plot was never carried out. Robert Shiver was not harmed. The case came to the attention of the Royal Bahamas Police Force through what investigators described as an accidental discovery. Officers conducting an investigation into an unrelated break-in at Grabber's Bar and Grill examined employees' phones as part of that inquiry. The messages allegedly connected to the conspiracy were found during that review. Robert Shiver subsequently notified police that he had reason to fear for his safety. All 3 defendants, Lindsay Shiver, Terrence Bethel, and Farron Newbold Jr., were arrested in late July of 2023. They were arraigned on December 8, 2023, before Senior Justice Cheryl Grant Thompson of the Supreme Court of the Bahamas in Nassau. The charge against each defendant is conspiracy to commit murder under Bahamian law, which carries a maximum sentence of 60 years. All 3 pleaded not guilty. Bail was initially denied for Shiver on July 31, 2023. It was later granted on August 9, 2023, at $100,000 for Shiver and $20,000 each for Bethel and Newbold. Shiver's original defense counsel was Owen Wells. She subsequently retained attorney Ian Cargill. In October of 2024, bail for Shiver and Bethel was revoked. The revocation followed media appearances, including interviews on Good Morning America and Inside Edition, during which both made public statements about the case. The Bahamian Court of Appeal upheld the revocation of bail in December of 2024. Bail was reinstated for Lindsay Shiver on February 13, 2025. The trial has been scheduled on 5 separate occasions: March 4, 2024, July 1, 2024, a date in March of 2025, August 29, 2025, and most recently, March 2, 2026. As of the date of this narration, no verdict has been publicly reported. During the period following her arrest, additional legal proceedings connected to Shiver were reported in American courts. Her divorce case remained pending in Thomas County, Georgia. The couple's 3 sons were in the custody of Robert Shiver during the proceedings. A man identified as Dorsey Ryan Love, described in reporting as a subsequent romantic partner of Shiver's, was arrested in Alabama in July of 2024 on a charge involving an alleged physical altercation with Shiver. The nature and outcome of that arrest were cited as factors in the October 2024 bail revocation. Robert Shiver was briefly linked in entertainment media reporting to Savannah Crisley, daughter of the television personality Todd Crisley, between December of 2024 and approximately March of 2025. This case has received sustained media attention across multiple platforms. Coverage has included CNN, Court TV, Good Morning America, Inside Edition, People Magazine, Fox News Digital, News Nation, The Nassau Guardian, and several podcast productions including Moms and Mysteries. The case has been followed closely by both American and Bahamian outlets. The evidentiary and legal issues in this case. The WhatsApp message, the alleged post-arrest confession referenced in prosecutorial statements, the accidental discovery by officers investigating an unrelated incident, and the repeated trial scheduling place this proceeding in a category of international criminal prosecutions involving American citizens that rarely receives sustained documentary treatment. Crime Doc will continue to monitor and report on this case as it develops. Lindsay Shiver was Miss Houston County, Alabama, in 2005. She is charged in the Bahamas with conspiracy to commit murder. She has pleaded not guilty. The trial is ongoing as of April 2026. No verdict has been entered. That is all 10 cases in this series. 10 women, 10 crowns, 10 courts, and 10 documented legal proceedings that show, without any doubt, that a pageant title is no barrier to criminal conduct, and no protection from the legal consequences that follow. If you found value in this documentary, please hit the like button right now. It takes 1 second, and it tells YouTube this content is worth sharing. Drop a comment below. Let us know which case stayed with you the most. And if you have not subscribed yet, this is the moment. Click that subscribe button and hit the notification bell so you are the first to know when the next Crime Doc episode drops. We cover real cases, real courts, real consequences. This is Crime Document. We will see you in the next one.